Hi, I'm Marc Stevens, author of Adventures in Legal Land and Government Indicted. My website, marcstevens.net. Do a radio show called The No Stay Project, which is live every Saturday from 4 to 7 p.m. Eastern Standard Time on LRN.FM. You can also go to marcstevens.net and you can check out local affiliates. And what we do on the show is help people. We want to help bring about a voluntary society, which is a world without the concept of government, where it is where one main rule applies, the non-aggression principle, or first do no harm. And that there's no exceptions to that. Just because you call yourself a government or claim that you're acting on behalf of a group, a collective, that somehow that principle of do no harm does not apply to you. And we help do. One of the ways we do this is when people are being attacked by bureaucrats, whether it's traffic, whether it's taxes, whether it's possession of a plant or something like that some politician decided 40, 50, or 80 years ago that you should not have, then we make these challenges. We're asking questions. And it's all we're really doing is asking questions. But when you prepare for court, you have to understand that you're dealing with psychopaths. I'm talking from the police officer to the court clerks to the prosecutors, the lawyers, and, of course, the main psychopath, the judge, the one with the robe on. And I say that because they have a callous disregard for other people's life, liberty, and property. They have absolutely no respect whatsoever for your personal autonomy. To them, we are their peons. We are their chattel property. My evidence of that, because that's what we do here on the No Stay Project, it's always evidence-driven, the fact that you are not asked to participate in their system. You either do it or you go to jail or you are killed in the process. So that's my evidence that they have a callous disregard for us because they don't ask us to do anything. They tell us to do it. They order us at gunpoint to do X, Y, Z. They're pathological liars. We're going to go through some of the lies that they tell. Almost every word that comes out of their mouth is going to be a lie. Almost every single word. And it's easy to document. You want to keep notes with you. I have my notebook over there. You want to keep the notes, or you can just because the lies are going to come fast and furious. You don't need to keep track of all of them, but the big ones, write them down. So just understand that you don't want to take court lightly when you're going in there. You're dealing with a psychopath. The fact that you can call him Bert or you can call them Sally and they'll fly into a psychotic rage because you use their first name is evidence enough to me that these people are psychopaths, that they have no regard for you. They don't handle questioning well, and you don't even have to call them by their first name. Some people may say, oh, well, that's disrespectful. Even if I give you that, do you put a man in jail because he called you by your first name, disrespectful or not? Psycho. So, knowing that every sentence that comes out of the judge's mouth and the prosecutor's mouth and everything that they're saying to you is a demonstrable lie. We take advantage of that. And to throw a monkey wrench into the works because their job is to make it look good. Because the average person is going to be looking at, well, you got your day in court. If you had a legitimate argument, if you had the facts and law on your side, the honorable judge would have thrown it out. But you lost, so you were wrong. A lot of people say, why would you challenge a parking ticket or a traffic ticket and why don't you just pay it? It's about principle. Some of us have the principle of right and wrong. And we respect autonomy, things like this. So what we want to do to throw a monkey wrench in the works is take advantage of some of their rules. So I have this will be available on the website as a template. It is an unsigned plea of guilty. And what it says is, I, Marc Stevens, enter this plea of guilty. The nature and cause of the charge and proceedings have been explained to me, and I am knowingly, intelligently, and voluntarily pleading guilty and waiving my right to appeal. Now, that has to be there in a general sense. Most of the rules want that. And you have to sign it. So when we go in and the judge says, all right, Mr. Jackass, my little peon, my piece of property, you, how do you plea? Say, well, I intend, and you hand him a copy of this. You got to have it in writing. This is now going to be evidence against this lying charlatan. So my intention is to plead guilty. Has the prosecutor, and you don't give him any chance to respond to this. My intention is to plead guilty. Has the prosecutor presented any evidence to prove the Constitution and laws of the plaintiff's state actually apply to me and that there's jurisdiction over me? Now, we know from experience there's no evidence. In fact, critics of mine come out and say, well, Marc, you don't understand the law. You see, the law is magic. The law is not just things written down on a piece of paper over here. We put the word law at the top, and then we give men with guns, and we say, you go out and you enforce this. And it magically applies to everybody. They say that the law Yeah, it's not about evidence. It applies to everybody because they said so. Because when you call yourself a government, you're more than human. This is why we talk about it being a religion, because they're elevated to this superhuman status. Just say it, and it applies to everybody. You're different than the average person. Well, that's BS, and I will get into that. So what the judge is typically going to do here, because this mini God thinks he's got jurisdiction over everyone that walks into his courtroom. He mistakes his willingness to use violence against you as jurisdiction. And he doesn't like to be challenged on it. And it's not even him that you're challenging. You're asking a question, has the prosecutor presented the evidence he's supposed to give you anyway? And he will usually get very, very upset, and he will lie. This is one of many lies that they're going to tell you. He will lie to you and say that jurisdiction is a trial issue. Now, we've had this happen all over the so-called United States. We have had this happen in Canada, Australia, New Zealand, and in Mario, England. It doesn't matter. They tell the same stupid lie. How do we know this is a lie? Because their own code says that jurisdiction may be challenged at any time. The fact that they're forcing you to an arraignment, there has to be jurisdiction for the arraignment, right? Well, if they're claiming jurisdiction, where is the evidence? You see, it's called misconduct to make an argument, even an argument of jurisdiction, outside the facts and evidence. And that's what they're doing. So the judge is going to lie. And another way to prove this, if you want some practical application to this, or if you want to just see in their own little codes, look at something like the ACLU versus the NSA. And it was kicked out for lack of standing and jurisdiction. There was no pretrial. There was no trial. They didn't turn around and say, well, Mr. NSA, we'll have to determine your motion to dismiss for lack of jurisdiction. We'll have to do that at trial. But you boys are going to have to come in and submit to that doesn't happen because jurisdiction may be challenged at any time. Yeah, even for the first time on appeal. But that doesn't mean it can't be raised and addressed and shouldn't be addressed and must be addressed when it is initially challenged. So if they're going to order you for an arraignment and they're going to claim that there's jurisdiction, that damn argument better be backed by evidence or it's arbitrary. So that's a lie. It is not just a trial issue. I can't stress that enough. And I know if you're a critic or if you're skeptical, great. Challenge jurisdiction at your arraignment in a traffic court or more serious, let it be a felony possession. And watch the judge lie to you. And then you just let him finish. And then you say, objection, you're wrong. Jurisdiction is not a trial issue. Oh, how do I know that? Because if I sued you, you'd file a motion to dismiss for immunity and a lack of jurisdiction. And you wouldn't wait till trial to do that. So it is a lie. And anyone, you can go on the interweb and you can research and you can find out jurisdiction may be challenged at any time. So the reason why we're doing this in writing also is because the judges, once you object and you call him on his nonsense that jurisdiction is a trial issue only, what a stupid thing, they're going to lie again. To get around the lack of evidence that the prosecutor is supposed to have, they're going to lie about you refusing to plea, even though it's in writing right on his bench, right on his exalted 4-foot wooden throne. That's why we do it in writing, because there's only two circumstances where the judge is permitted to enter a plea of not guilty, even over your objection. One, if you're refusing to plea. Two, if a plea can't be ascertained. Once again, it's a plea of guilty. So you can clearly ascertain what I'm trying to plea. You can clearly see the evidence is there. It's right here. I'm not refusing to plea. What he's doing is he's lying that you're refusing to plea to cover up for the prosecutor's lack of evidence. So there's evidence of collusion between the judge and the prosecutor, or if there's no prosecutor, between the judge and the cop. That judge is so desperate to put you on trial, he will assume the burden of proof on an essential element of the crime, including, which of course is jurisdiction. Because an essential element of the crime is going to be the applicability of the Constitution and laws, because that's what the courts are enforcing. That's what the courts interpret or declare. It's all about the Constitution and laws. There's no evidence that applies to anybody. So that's what he's going to do. He's going to lie. and it is a lie, and you need to object, I would object right away, call him on it, and say, excuse me, I know enough that you've got two situations where you can enter a plea on my, over my objection, when I'm refusing and when you can't ascertain. Do you need another copy? Do we need to go through this again? I'm trying to plead guilty. So, and you call him. I said, well, I think what you're doing, sir, is you're being dishonest and you're assuming the burden of proof for the prosecutor. You're lying to cover up the prosecutor's obvious lack of evidence. And more than likely, he's just going to, in a fit of rage, he's going to just set it for, he's going to enter the plea and he's going to give you a pretrial date. Now, this is a huge due process violation and a violation of fundamental fairness, because that goes into number 2, and it all ties in. So we've got lying about you pleading. So if you're going to do a motion to strike the plea, which I suggest, and to change the judge, you have to show a bias that arises from an extrajudicial source. Well, if he's lying to cover up for the prosecutor, it looks like it's from a political source. So it's not it is extrajudicial. Something's going on here. And you have to show that the bias is so great that you cannot get a fair hearing or fair trial. Well, if he's going to lie about you pleading to cover up for the prosecutor's lack of evidence, I think we've established sufficient grounds that this psychopath should be removed, disqualified. Should be in jail, should be in one of the prisons that he sends his victims to. So that's a huge due process violation, which leads into point number 2, which is a huge due process violation, fundamental fairness. What he's doing is, when he is assuming jurisdiction, by assuming that the Constitution laws apply and he has jurisdiction over you, that is an element of the crime, because you're always charged with violating their code, their laws. Well, the applicability of those laws is an essential element of the crime, especially if it's something like growing plants out here, where it's a crime in name only. It's just because some politician said so. So it has to be proven beyond a reasonable doubt, and it has to be proven with evidence that the Constitution laws apply, to then be able to prove beyond a reasonable doubt you violated it. So you see, you're injecting logic here, which drives the psychopaths crazy. Judges do not respond well to logic. Not at all. So you're showing that the judge is assuming the burden of proof of the prosecution, that the prosecutor has to prove every step of the way jurisdiction. He has to prove at trial beyond a reasonable doubt. This evidence has to be there. He doesn't have to present it and put his witnesses on the stand and whatnot, but the evidence has to be presented to lead a reasonable person to believe that the Constitution and code apply, and the court then has jurisdiction. So he's assuming jurisdiction on behalf of, this is an essential element of the crime, at the arraignment, within 2 minutes of walking in, up to his wooden throne, which leads us to major due process violation number 3. The judge is required, not the cop, not the prosecutor, not the clerks, the judge and a future jury, if there is one. They're the two parties that are required to presume you innocent of every element of the charge. Okay? Now, that includes the applicability of the code, because, again, logically, you can't prove the code was violated until you first prove that the code applied. So what the judge is doing by assuming jurisdiction on behalf of the prosecutor, who has presented not one shred of evidence, he is refusing to presume innocence. So this is something you object to, and you call him out on. Say, excuse me, am I presumed innocent here? Remember, to have a fair trial, they have to presume you're innocent until proven beyond a reasonable doubt. So you ask him, objection, am I presumed innocent of every element of the crime, yes or no? Oh, I am? So you're not presuming that the Constitution and laws apply to me. Now, I've had hearing officers and I've had judges actually say that they were not assuming that the Constitution laws applied, which gets them into a pretty tight bind. How can you assume that there's jurisdiction to even hold me here for an arraignment if you're presuming the Constitution and laws don't apply? That's the basis of their jurisdiction. So we can prove the fact that he's setting it for a pretrial. We can prove that he's not presuming you innocent, and it's impossible to get a fair trial when he's not only refusing to presume innocence, but that he is actually assuming the burden of proof on behalf of the prosecution. These are 3 major due process violations and fundamental fairness violations, all within 3 minutes or less of walking up to his wooden throne. So we're just getting started here. Now, you don't even really have the time to get into some deeper issues because he's going to throw you out. this psycho is going to throw you out. So what you're able to do is file a motion to strike the plea and disqualify the judge, because obviously you can't get a fair hearing from someone who is lying. And how do we prove he's lying? I didn't refuse to plea. He's obviously covering up for the prosecutor. And we file a motion to vacate and disqualify the judge. We'll talk about this and a whole lot more on the No Stay Project on LRN.FM, and all the podcast is available at markstevens.net. But if you're going through a problem and you have a ticket or a complaint or an indictment that's filed against you, feel free to call the No Stay Project. Let us know if there's something we can do to help. If you're doing something like this and you have the parking ticket study that I have at markstevens.net, you're welcome to participate. Get a copy of this. Let us know what's happening, what we could do to help, and report back to us so that we can have other people independently verify and report to us that these judges are lying and continually saying that jurisdiction is a trial issue. I look forward to more feedback on that. And again, like always, if you have any dissent, criticism, or skepticism, which is highly encouraged for all the material that we do here on the No Stay Project and on markstevens.net, call into the show. We do a live broadcast. I know you can't see all the equipment here, but it's minimal, but it gets the job done, and we don't screen calls. So if you have evidence that the Constitution laws apply, or you have evidence to refute what I presented here or any part of my videos on YouTube or on markstevens.net, you're more than happy. I'll even schedule you as a guest, and we'll put you on a live broadcast. And I can't record. It's a live broadcast. I can't control the recording of it. Can't. It's a live broadcast. So I'm even willing to go on a show of your choosing. So if you can set up another show and you think I'm full of crap, I'm more than happy to meet you at the door every time on another show. If you think that there's evidence the Constitution laws apply, or that a judge can assume jurisdiction on behalf of a prosecutor and still presume you get innocent at the same time, step up. I'd love to hear it. Again, it's the No Stay Project is live every Saturday from 4 to 7 p.m. Eastern Standard Time, and I welcome your dissent.